Welcome to Police Custody Basics, and my name's Joanne Caffrey, and in this scenario we're going to look at the issues of why someone was acquitted in relation to a drug driving case for fail to provide. So we have the police officers stop a vehicle based on information received that the driver may be a cannabis user and driving. They stop the vehicle, they require a roadside saliva test, and the person refuses to provide it. So they're arrested, they're taken to the police station, and the MGDDB procedure is commenced in relation to impairment through drugs. So the driver is seen by the HCP, and the HCP apparently concludes that their behaviour is impaired through drugs. So the police officer then has the power to request the blood sample, of which then the driver declines and they refuse to provide the blood. So what are the issues with this then, and why were they acquitted at trial? The issue is then that there was no HCP statement of evidence, there was no HCP medical notes, and there was no HCP detained person medical form, and the HCP was not called as a witness for the trial. So it has to be demonstrated that the HCP believed that the person was impaired through drugs for the station requirement to be lawful. But there's no evidence to demonstrate that. In fact, the evidence is contradictory, because then when you look at the custody record, the HCP recommended that the driver be a level 1. So from the 4 levels, that's their level 1, 2, 3 and 4, if a person is believed to be impaired in any way to the minimum level, they need to be at least a level 2 detainee. If they're believed to be impaired to a higher level, then there would be a level 3. But in this case, the HCP recommended they were a level 1, which means no foreseeable risk and doesn't fit with the scenario then that they were impaired. The custody officer, who wasn't called to the case neither, they also classified the person as level 1. So again, if they believed that the detainee was impaired through drugs, they should have assessed the person of being at least a level 2. The next issue, which contradicted the case, was the fact that the HCP recommended that the person is fit to interview. Now, the basic principle, if you look at the police custody expectations, is that a person is not fit to interview if they are impaired through drink or drugs. So again, if you're saying the person is level 1 and you're saying the person is fit to interview, then that is contradictory to the allegation that this person is impaired. And therefore, the case collapsed on the morning of trial and they were acquitted. So, thank you very much. Joanne Caffrey, Police Custody Basics.